So this is my 2021 Planning for Your Young Adult webinar. Super important if you have kids that are 17 or older that are in college, whether they're away or they're local. This is something that you can really prevent a lot of grief, and I'll explain why. So first, a little bit about me. I'm Irama Valdes. I am a probate, guardianship, and estate planning attorney. That's me with my beautiful family. I began 11 years ago. Was it 11? It's going to be 12 soon. But 11 years ago, I started being a lawyer. I did not work for myself back then. And then in 2015, I landed the most important job of my life, and I was promoted this June. And that is a job of mom. So that's priority number one. Business is second. And those are my babies. That's my daughter. She was born in June this year. And in January of 2016, I opened up my own firm. I was working in downtown before and spending 3 hours commuting, which was no bueno for wanting to spend time with my son and being the mom that I wanted to be. So I opened up my doors in 2016 and I haven't looked back. And the most important part of what I do is education, which is exactly what I'm doing today. I love taking time if I'm going to take time from my kids, it's going to be to do something that's going to help people, like workshops and webinars, and spreading how important it is to get your stuff in order. Whether you're 65 or 18 years old, it is so important to have your estate plan in order. So why is it important for young adults to have their estate plan in order? I mean, they are literally young adults. They don't have assets. And even if they do have assets, they're not significant. So why is it important? Well, if you're a young adult, no longer a minor under your responsibility, even though I'm sure, especially if you're Hispanic, you're responsible for them until they get married. And even then you're still responsible. I'm being funny. So why? So when an adult is of age, when a child is of age and they're an adult, if something happens to them, and I'll get into that, what the if is and what could possibly happen, you as a parent will want to make decisions for them. You would want to make financial decisions for them, and you'll want to make healthcare decisions for them. Obviously, I think at this point, healthcare is probably a little bit more important, but that's going to be your main priority, is making sure that they're okay. If they need surgery, making sure that you can authorize the surgery. If they need, to apply for government benefits to get that assistance, whatever it is that they need, you want to do that. That's your role as a parent, right? But the law doesn't care once they turn 18 that you're their parent. You're just another person. They're an adult. They can make decisions for themselves. So if something should happen, a car accident, a terminal illness, even a disease that's temporary. I mean, what better example than COVID? Anything that renders your young adult incapable of making decisions for themselves, you're going to need some sort of thing to be able to decide for them. If you've planned correctly, then they have their estate plan and they've named you or whoever they trust, and I'll get into that after, as the person or people to make financial and medical decisions on their behalf in the event of an incapacity. If they have not planned correctly, then as the parent of this young adult, you will need to open up a guardianship. So a guardianship, there's actually two different types of guardianships. For purposes of this webinar today, we're going to be talking about the first, which is guardianship for an incapacitated adult. But I'd like to go briefly into what a guardianship for a minor child is. Hold on. I'm going to pause really, really quick because so many people wanted to join, and the person who organized this is saying that they're lost. So give me just a second. All right, I'm recording again. Just a little hiccup. All right, so the next kind of guardianship is a guardianship for a minor child. This is if you have a child that's 17 and under and a parent dies. and either one of the parents die or two of the parents pass away, and you need a guardianship to be able to manage their care and or their finances until they reach 18 years old. So that's obviously not what we're talking about today, but really good information to have. If you know of anybody that's in that situation, they will need a guardianship. So a guardianship for an incapacitated adult is a case where you're asking the court to make a determination of incapacity, and then after that determination of incapacity is made, then to appoint a guardian. So the first part that happens is that we have to ask the court to determine this person incapacitated, whether it's an accident, whether it's a disease, whatever it is. That court has to make a determination of incapacity before they can actually appoint someone to make decisions for them. So there is an incapacity hearing, and then during that incapacity hearing, the court can appoint someone as a guardian. So the most important question that my clients ask is, okay, so who is the person that's appointed to make decisions? Usually it's the family, parents, siblings, cousins. I mean, whoever is the closest person or the next of kin to that person, that's who the court tends to appoint. But if a family can't decide, or if parents are divorced and they're fighting, then really it's up to the judge. So just a quick snippet of the law. Any resident of this state who is 18 years or older is actually qualified to act as the guardian. And really scary, at least for me as a mom, is that the court can appoint any person who is fit to act as guardian, regardless of whether they're related to the ward or not. So the ward is the person that's potentially incapacitated, but imagine someone that's not related to your child acting as their guardian. This is, I know, I put Home Alone, that's my favorite. But that's incredibly scary to me. So let's say all is well, the court appointed mom and dad. After that, the guardianship has to stay open, and there's certain requirements that have to be met until the child either regains their capacity or passes away. I know we don't like to talk about those things, but here are some fun facts about guardianships. I like funny memes, so you'll probably see those sprinkled throughout the webinar. This is actually two court cases. It's not just a guardianship case, it's a mental health case and a guardianship case. What that means is that you're going to have to spend a lot of money on attorney's fees and court costs in order to establish this procedure. So it's a mental health case to determine the incapacity, and the guardianship case to appoint the person. And the court appoints whoever believes is in your best interest. In the situation for your child, it could be you, it could not be you. I mean, I can imagine people that are divorced may not want the other person to serve as their child's guardian. And I have cases where mom and dad are fighting over who should be the guardian for their child. Not pretty. All your assets get placed into a guardianship. Because they're young adults, you don't expect them to have many assets, but if there is a bank account, or if they have something significant, or maybe they have an inheritance, all of that gets placed under the purview of the court and under the control of the court, which, by the way, is public. Anything that happens in a guardianship case is public. Now, the mental health case is private because all the determination of incapacity is confidential and protected according to the Florida statutes. But the guardianship part, as who gets appointed, what actions go on there, all of that is public. When does it end? As I stated before, it ends when the person's incapacity goes away or when they've passed away. So if it's a car accident and they're in a coma, when they come back from the coma. If it's COVID, when they recover from COVID. If it's a terminal illness, then unfortunately it's when they pass away. If it's someone with special needs, and I have a lot of cases like that, where it's someone that has autism or Down syndrome or learning disability or schizophrenia, anything that could render that person incapacitated, that's a lifetime guardianship. And like I mentioned before, the court requires you to do certain things on an annual basis. So a few scary examples. One of these examples don't apply to young adults, but it's so important. I had, and I'm going to change her name because obviously I can't say her name. I had an 88-year-old client, and her name is Betsy. And she came to see me to do her plan. And about a week after we did her plan, I don't know why we were looking into the docket. I can't remember why, but my paralegal found a mental health case against her. And we had just prepared the documents that we're going to talk about today. Unfortunately, her daughter filed a guardianship against her, and there was also a domestic violence case, let's put it that way, where her daughter was abusing her. Luckily, we won against her daughter in the domestic violence case, and we obtained a restraining order against her. But unfortunately, these documents weren't done in time because that mental health case was open right when we were creating these documents. And if you think this only happens to the elderly, where they're incapacitated because of old age or dementia or not, you're absolutely wrong. This year, and this was one of the saddest cases, I initiated a guardianship for a 31-year-old woman who was left brain dead due to the effects of COVID. I had never heard of that happening, and I am on top of the news as far as COVID is concerned, but I guess COVID left her in such a state because of the oxygen and the respiratory issues that she was not able to make decisions. And even though that case was straightforward and there wasn't anyone fighting as to who could have been her guardian, it would have been really sad if we had to engage in litigation for a 31-year-old woman who unfortunately had a really, really bad case of COVID. So how is it that your family avoids this hot mess? Again, okay, maybe not a meme, this was a GIF. But most importantly, it's so important to understand that you have to create an effective estate plan. And if you're a fan of Friends, yeah, this one's for you too. So a lot of people say estate plan and you don't really know what an estate plan is. So I like to kind of break it apart. So you see 5 circles here because for me, it's 5 different things that you have to worry about. But estate planning in general is carefully considered and documented decisions regarding your family, your property, and your future, and also your children's future. So think of it as decisions that you can make. So the first kind of decision is medical, and not so much, and medical is kind of branched into 2 different types of decisions. So medical who, in other words, who can make medical decisions for you on your behalf? This is done by executing a designation of healthcare surrogate. The second type of decisions are medical what? What kind of decisions can be made? What instructions are you going to put on paper that say, if I'm ever in a terminal condition, if I'm ever in an accident, I want you to keep me alive for 18 months, 2 years, 5 years, whatever length of time. I want, 7 doctors deciding that I can no longer be resuscitated. And for a young adult, it's important to make sure that you've exhausted all of those options to be able to extend their life if possible. I mean, I have 80-something-year-old clients and they're like, oh, if I'm not breathing right and I have to be, don't resuscitate me, just pull the plug. But I can't imagine the same decision is going to be made for someone who's 20 years old. The next set of decisions are financial. This is managing checking accounts, savings accounts. I mean, for a young adult, it's going to be very minimal. Think of their college tuition, dealing with the registrar's office, dealing with a 529 plan or Florida prepaid, anything that they would have to do with regard to their finances, that's what the power of attorney is for. Altogether, those 3 documents are called advance directives. So that's pretty much what we're discussing here. I wanted to touch up on the second part of the estate planning just for purposes of being thorough. But the 4th type of decision are testamentary. That's who gets your stuff, in how many shares or what amount, and who is the person that handles your estate after you pass away. And then legacy, which young people are far from this. When I say young, I mean college, because I'm still considering myself young. But legacy is more like if you have minor children and you want to postpone the time that they receive, your assets, you want to make sure that you have guardians listed for them if something should happen to you before they turn 18. That's what I mean by legacy decisions. So the designation of healthcare surrogate is the document where they name someone to make medical decisions. The living will is what kind of medical decisions, and the power of attorney are financial decisions. Now, some things that they have in common and some things that are different, all of these can be modified or revoked. If something happens where your child no longer wants to name you or name whoever it is that they named to make decisions, they can always revoke it and say, I don't want this anymore. Now, one of the biggest differences between the healthcare surrogate and the power of attorney is the validity versus the effective date. A healthcare surrogate is valid the day you sign it, but is not effective if and until you're incapacitated. So a lot of college age kids may be reluctant to sign these documents thinking that they're giving up their autonomy to make decisions for themselves, when in reality, all they're doing is making sure that the right people are making decisions for them if they become incapacitated. So that healthcare surrogate, they're going to be making all of their healthcare related decisions if and until they cannot. So if they go to the doctor and the doctor asks them a question and say, do you want to do this? If they have capacity, it's up to them. It's not up to the parent, despite what that document says. Now, if they go to the doctor and they don't have capacity, at that point, the doctor is going to look for who their healthcare surrogate is to be able to take direction as far as their medical decisions are concerned. Now, the living will is the document that tells that healthcare surrogate that they name what kinds of decisions they want to make. Like I said, whether they want to be unplugged if something's really wrong, where they want to live, anything that has to do with their body. That's the kind of decisions that are going to be included in the living will. Now, in the power of attorney, that is unfortunately now valid and effective the day you sign it. So whoever it is that they're naming as their power of attorney, they are going to be able to act under this document immediately. So one of the things that we talk about is making sure that you choose the right person to make these financial decisions for you, because the last thing we want to do is have someone take advantage of this young adult. So very important to make sure that you choose the right person. Hopefully mom and dad are the right person, but the most important part to take away is that with these documents, the young adult's family can avoid guardianship and avoid having to spend that money. Just to give you an insight as to how much I charge for guardianship. When we have to start a guardianship from scratch, which is usually the case, unless I'm taking it over from someone else, I charge $5,000. And this is not a flat fee. This is a retainer to which I work against at my hourly rates. And in addition to the $5,000, the court fees have to be paid. And the court fees are approximately between $700 to $800. That includes a filing fee for the mental health. That includes a filing fee for the guardianship. And if any other documents need to be procured or mailing or any other costs associated, that's what's included in there. For advanced directives for young adults, what I'm doing is kind of like a package deal for children ages, well, I say children because they're still kids, but young adults ages 18 to 25, or if they're still in college, in their 20s, for $500. And this includes the healthcare surrogate and the power of attorney. Those are the two documents that will prevent having to open up a guardianship. So it's so important to just get this done. And it's incredibly cost effective when comparing it to having to open up a guardianship. But a lot of people don't do this because they just don't know. So how do you get started? The first thing that I do is I send your young adult a simple questionnaire where this process is explained to them. It's going to have a video where I explain everything about healthcare surrogates and powers of attorney and the pros and cons and do's and don'ts and all of, everything that you saw today it's in that video, together with a questionnaire that has explanations as well as to what each document is and what it is that the information that I need from them. And then once we receive that questionnaire, we set up a Zoom meeting, usually about 15 to 20 minutes, where I talk to them. I make them feel comfortable with me, because that's really important, that they feel this is usually their first experience with a legal matter. I mean, they're freshly minted adults. So it's incredibly important for me to make them feel comfortable, so that they feel comfortable asking me questions about this process, about, well, what if I don't want to name my dad, and that's okay. One of the things that I tell parents is, like, I know I'm giving you this information, and you're facilitating the meeting between me and your child or young adult, but they are the client. So whatever they tell me and whatever it is that they ask me to do, that's my job. I have to keep it confidential. I have to do what they say. So let's say everything goes well. They say both parents or one, however the situation. Step 3, I prepare the documents. And then once we prepare the documents, then we set up the signing conference, which is usually in my office, or if they're away at college and they want to sign remotely, that can be done using the services of a remote online notary. I am personally a remote online notary. However, I have started using a company, and they just make it so much easier, because they do this day in, day out. I mean, I do this once or twice a month. They're doing this 5-6 times a day. So happy to connect you with my Ron provider. But that's pretty much it. It's a simple process, maybe takes a week or 2 at most. It's really, it's not a difficult thing, but it can really solve so many issues going forward if you have a guardianship, or if you have the need for a guardianship. So if there are any questions, please feel free to unmute yourselves. Like I said, you don't have to be on the camera. I would have been in my pajamas if I were attending this webinar. So please feel free to ask any questions. You can ask questions in the chat. I'm the one monitoring that as well. I'm a one-woman show. And yes, I'm happy to send the link to the presentation. I don't know how good the video is going to be, since I had to pause it in the middle and I feel so bad, but something is better than nothing, right? So.